My name is Martin Halliwell. Welcome to another episode of Value Engineering Experts. Past episodes can be seen on footprintengineering.ca, the sponsor of this wonderful idea. And the goal here is for me, is to lower CO2, which saves cost and schedule, but also to have a variety of guests with a variety of contributions to intellectual property. Today, we have a very special guest, Ashley Burk. And Ashley, welcome to the Value Engineering Experts.
Thanks, Martin. Happy to be here.
So Ashley has got an interesting, I'll do a little bit of an intro for her, and she certainly can talk for herself as we ask questions. Her background is, she was an engineer first, which is interesting. And there'll be lots of engineers listening, but also many tradesmen. And I think both groups of people that I try to appeal to in an innovative way can get a lot out of this particular podcast. Ashley chose, after taking an engineering degree, to pursue a law degree. And in particular, she's an intellectual property specialist. And interesting always to learn about people's background. But Ashley, your parents were technical. Your mom was actually an engineer, right?
Yeah, that's right. It's what makes me so useful in this area of business is that I come from a background of scientists and engineers. So my mom was an engineer, and her dad, so my grandfather, was an engineer, and his dad, so my great-grandfather, was an engineer. And my dad is a professor of chemistry at Carleton University. When we were speaking yesterday, Martin, I was surprised to learn that we actually have some commonality in our history. So I know that you worked for the St. Lawrence Seaway, and my grandfather was actually the head of mechanical engineering in the engineering services branch there. So he was responsible for, the design and the specs for the Canal movable structures, like the movable bridge machinery and the lock gates and valves, the powerhouse machinery, that sort of thing.
It's a fascinating engineering structure. I think at one time, had a lot of accolades. I worked on it in the early 90s when it was being rehabbed. And so I had an early experience in civil engineering and in terms of civil, what you call civil contracting. And it kind of led me to understanding the rehab nature and the cost of something like that. What we did, Ashley, is we actually took 2 to 3 feet off the canal walls, which are 80 feet high. And the concrete was porous. And, you and I will touch a little bit on some of the footprint patents today that you've helped me with. So just for the background for our listeners, Ashley's firm has done a lot of work on the trademarks, and with her partner, Neil Tannenbaum, her business partner, Neil Tannenbaum, who is a very experienced patent agent. So today we'll learn about patents, trademarks, Ashley's journey, and to what I'm going to call a value-based existence. Is very interesting. We share a lot of values relative to earth honoring systems, which is one of the trademarks she helped me with. We recently got that in the States, right, Ashley?
That's right. Yeah.
So that was there's always these good days when you get the patent, or when I've joked around about stopping at 12, but it's keeping me pretty busy, I tell you. And thank you a lot for all your help. Some of them are quite significant, as you know, particularly the waterproof concrete one, which if the Seaway had that in their walls, they probably would never have to rehab it again.
That's right. Yeah.
So interesting. So tell me a little bit about when an engineer needs to think about reaching out to an intellectual property.
Yeah, sure. What is so gorgeous about my business is that it isn't all reactive like a typical lawyer that reacts to the bad. So there's a lot of proactive work that comes with trademark and branding law and patent law. And so our clients actually get the chance to know us, right? We get to know them and support them. And there's a really lovely sort of immersion that happens when you get to know your clients. You build an ongoing relationship, which is not necessarily the case with a lot of other types of lawyers. So, I think it's important to have your IP lawyer on speed dial, like you do with me, Martin, because as we as we come to know and understand your business, we can better advise about strategy. IP is all strategy. It's at its most basic level a disclosure of ideas to the public in exchange for a monopoly, right? But sorting out the bounds of that monopoly, when to disclose, how to monetize that monopoly is all a matter of strategy. So having this ongoing discussion with your IP lawyer makes a lot of sense in all stages of your business before you even incorporate, to choose your name, to make sure that you're free to use it. After you've chosen your name, to protect your trademarks in the way that Footprint does by filing trademark applications for all of your brands before you disclose your inventions to the public, making sure that you're protected in that way. So it helps to have this ongoing conversation with your IP lawyer.
So do you do any marketing other than coming on my podcast? Like, do you actually have a website?
I do. I have a website. It's burk.law. But no, I don't really advertise. I tend to like to build relationships, are meaningful through, my other clients and through the other lawyers that I work with. So that's primarily how my business gets out there.
Yes, I remember Neil, I got involved with Neil and Helen, who was a previous trademark person, and she was quite bright. And he said to me, oh, you'll like Ashley. She's very bright. So, or very smart. I forget exactly the description, but also, it's interesting to hear that you have two little boys, and that. Yeah, what are their names? I didn't write them down, but
I have two little guys. Spence is 9, and Gray just turned 7.
Something you told me about Gray is that he can actually do multiplication of 3-digit numbers.
Yeah, he's a wild man. He's comes in a tiny package. He's the smallest 7-year-old you've ever seen. But his brain is sort of a work of art. He can multiply 3-digit numbers in his head. He can, he comes up with statements that will just knock you off your feet. So he's brilliant. Spence is also brilliant in sort of a different way. He's got this capacity to sort of transform, between 2D and 3D objects. So I guess it's in the genes. The engineering is strong in this family.
Yeah, that's very interesting. So the need for intellectual property, you went to work with a more traditional firm after getting your engineering degree and realizing that the law interested you. You went to work with a larger firm that did intellectual property, and then you decided to go to a smaller firm. Can you tell me about that step?
Yeah, I did engineering first, like you mentioned, at Carleton. So I did engineering physics, which I always joke is essentially, theoretical electrical engineering, so a little bit impractical. And then I guess towards the end of engineering, I began to sort of recognize that my contribution likely wouldn't be in engineering per se, but rather in creatively supporting engineers and other professionals. So I looked to law, and in particular to IP. And then I went and worked for a boutique IP firm that had roughly 60 people when I started. That was about 12 years ago. And then I guess it's been about 2 years ago now that I started my business, Burk Law. I try to approach everything I do with curiosity and an attitude of, how does this connect to the bigger picture? So I try to make sure that everything I do in my work life and in my personal life supports what I want to see in my community, right? I treat it as an ecosystem. That's one of the biggest reasons that I opened this firm after having been at this larger firm, was because I wanted to take on the kind of client that I wanted to take on. I wanted to take on clients that align with my values and my worldview. You're a great example of that, Martin, right? Your interest in earth honoring systems and making sure that what you do, also aligns with your personal values, right? It's sort of a cohesive worldview, and you bring that to everything you do. And I wanted to bring that to everything that I do too.
Yeah, no, we tend to feed off each other day to day when we get involved with ideas. I'll run around to second base or third base, and Ashley will pull me back and she'll say, well, is that really the right strategy? So you have a lovely way of correcting my speed and slowing me down, so there's a little less tactical errors along the way. But we've had success, and you know, Neil's great, and I very much appreciate the combination of people that's involved with his business. Like, he has some interesting people in terms of I forget the other engineer that we dealt with for one or two of the appeals, because what's happened is, just to go to our patents, we've had some where we had to explain better. What do you call that when you have to actually resubmit a better explanation? Right. Because maybe prior art was understood to be in some way preventing the patent. We've had good success though with Neil. You know, he's a very good architect of that, drafting that patent, one of the best.
It's part of, you know, it's partly that Neil is a great patent agent, and it's also partly that that dialogue that we were talking about, right? So getting to know your business and understanding, you know, what it is that you're aiming for, understanding, you know, not just the inventions that you've come up with, but the purpose behind them and what you're going to do, you know, with them in sort of practical life. All of that is really important for sure. Yeah. And Neil's got a great team behind him as well. So all of that contributes. You could
probably touch on, for the benefit of our listeners, the fact that, you know, to get a trademark is not that expensive, right?
Yeah.
And even to get a patent, right? If there's merit. Yeah,
that's right. Yeah. So trademarks are generally less expensive to file applications for, but no less important. Filing in Canada for a trademark application is about $1,000. It's not a very in-depth process. You know, there are fees down the line, but all in, you're looking at about $2,500 to register a trademark. In terms of the cost of filing a patent application, if we're talking about a fulsome patent application, you're looking at around $8,000. But, you know, a discussion that Martin, you and I have often had is that this is worth it, even when money is tight, right? I know that you feel that way as well. Yes,
I mean, like, I literally believe that, you know, there's some sense of urgency to climate change and to the need to reduce CO2 in the built environment. So that keeps driving me to try and, you know, monetize the patents, make the difference day to day with using them. So that's where I'm at now, whether I'll create more. But in terms of what advice you would give a tradesman, or, you know, often, you know, it's somebody who's a non-engineer that can be as creative or more creative than the engineer. You know, yeah. The engineer often will pigeonhole himself into a detailed design mindset, pretty technical, maybe go for a master's of engineering or a PhD. Nothing wrong with that. But how many of those guys would necessarily have worked in industry or let's say saw practical applications the way a tradesman might? I would encourage people listening today, if they're a tradesman, and there will be many that will listen, you know, they too can get your assistance and Neil's assistance if they figured out a better widget, right?
That's right. Yeah. And, you know, you can always start by filing what's called a provisional patent application in the US. So this is a technique that we often use, which is, it's essentially a placeholder patent application. So it doesn't get examined by the patent office, but it gives you essentially a flag in the ground, right? You're staking your claim. And so as of the date that you file that application, you have a year to sort of flesh out the details and file a regular patent application. So it still needs to be, you know, a finished concept that you're filing this provisional application for. But it's sort of a cost deferral technique to sort of see if that idea has if it's going to have wings in the market, right? And this is something that can be done directly by you, the engineer, the inventor, the IP holder, or usually at a reduced cost by a patent agent. So it's sort of a nice technique if you've got a really great idea to file this provisional patent application. Give all the details in that application, and then take that year to decide, does this idea really have merit in the marketplace before fleshing out that idea into a normal patent application that will actually be examined and will lead to a patent.
Not to get too contentious, but to mention Trudeau, and I have a red shirt on, and I'm probably more conservative looking at spending equations and whatnot, and where we're at with our deficits. But Trudeau had a program, and I thank him for it, because we were able to quickly use it, where he wanted to spur innovation, I think green innovation, and as long as it was motivated by that. Can you explain a little bit how we've used the patent highway and Trudeau's program, why it's unique, why it was unique?
Yeah, so in Canada, there is the ability to file patent applications claiming that they're green tech applications. And this means essentially that you get to skip the line in terms of examination of your patent application, have it examined earlier than it otherwise would be examined, which can be beneficial for a wide variety of strategic reasons, right? So first of all, getting your issued patent sooner is usually a good thing. It also gives you the feedback earlier so that the Canadian examiner is having a look at your invention, and they're saying, yes, this is patentable, or, no, it might not be for these reasons. And so you can make a better decision about whether to file to protect your rights in other countries at a sooner date, which is often important.
So, and I think Neil commented that his experience was that you're greatly increasing your chances after being reviewed in Canada to then do a provisional patent in the States, which still gives you patent pending down there, and possibly not spend the money yet to defend it in the States. But the fact is that, it has to be of some merit, but when you spend the $7,000 or $8,000 to file it in Canada, you're really more than halfway there in terms of getting to a market that's 10 times bigger.
Right. Yeah. So, you can obviously use that, and it's not of any legal value in terms of whether or not other countries will, grant you patent rights in their country or not. But there is sort of the psychological value of, okay, this first country that examined it said that it's acceptable and therefore will follow suit as well. But you raised a good point in terms of, filing provisionals, which is that it gives what you call patent pending, right? So you can hold this up in front of various people, and it's of good value, right? You're able to leverage that to create new revenue streams and to gain access to financing. So leveraging this value in your IP is one of the main reasons that we often suggest to clients that they file trademark and patent applications, right? So, you generate income for your business by licensing your brands and your patents to other companies in a similar way to what you do with your businesses, Martin. And Martin, you're an absolutely prolific inventor. Like you said, you joke about stopping at 12, but I don't think that's the end for you. But you've built your company around around the concept of licensing your patent applications to third parties in exchange for royalties, right, paid to the company by the users of those technologies. So it's a really great strategy for value engineering firms like yours.
Yes, I would encourage everybody to think about their best idea and to actually call Ashley and get her advice. I don't think you necessarily need a retainer to answer the phone. No. I think you're the nature of an intellectual property lawyer, I think, is to meet interesting people and interesting inventors and it must have been a great journey to move over to that. Now, maybe you should take an MBA. I don't know. But you have as good a strategy grasp as I've ever met anybody in my MBA programs. You know,
I'm learning everything I need to know about business from you.
Yeah. You know, it's interesting though, for the benefit of the listeners, that we have to adjust our idea to not ask for too much now for, let's say, our main patent, which is this bathtub solution, which saves $8 million conceivably on a 2-acre excavation support work with tremendous value added on schedule. So to go to our lower CO2, it always lowers costs and schedule. And the built environment, and I think you know from listening to me that the built environment generates 40% of the CO2. So we want to reduce concrete and steel, and that's generally things that Ashley's more than willing. I can phone her anytime, and you know, it's been a very rewarding relationship. I know that Sarah enjoys a lot of the help you give to try and figure me out, and Sarah Taylor's our VP of Admin. And as we proceed, you know, I tend to have more guests on the podcast who and I'm going to encourage them to capture their most creative moments and to actually look at protecting them. Now, that being said, I've evolved to think that maybe nobody wants to cut a big check right off the bat. But you know, I've been talking to Robert Tofam, our engineering manager, about, you know, trying to make it easier to jump over the hurdle. And I think you agreed with that, you know, prove a concept. Everybody says, where have you done it before when it comes to construction projects? So we have a little bit of a barrier to entry in that sense. And we're adjusting with some of your advice, you know, to actually lately I've been thinking of just charging a few dollars a square foot, but try to get something up front where I could get the client comfortable, right? Get the client comfortable.
Yeah.
So that's our plan now. And I think we have real interest. We're starting to do, yesterday we did an engineering presentation, lunch and learn. And of course, the guy thought it was great in terms of this has real potential. Where have you done it before? Right. So we have to get people to jump over that little bar in a construction sense, because it's so innovative compared to what's going on in the downtown Toronto area. But we could save people a lot of money, and it's significant. Anyway, that's very interesting. So what would you like to do? You're just going to let your boys do whatever they want. They'll figure that out.
Yeah, I mean, I think you know, with kids, you just have to give them access to the tools that they need, right? You can't ever control the outcome. I guess that's also the difference between law and engineering, right? Engineering, there's only one right answer. And in law, you know, there's room for creativity. It actually goes back to a point that you just raised, which is kind of funny, that there's always room for creativity, right? You know, in these ideas that you have, and in the way that you bring them to the market, and the way that you monetize them. You know, we can design licensing agreements. We can create these agreements to match almost any situation that you come up with. And that's one of the sort of fun parts of my job is working with inventors like you to sort of, you know, figure out what works in the marketplace, and to figure out, at what point do people buy into this idea? At what point are they going to take it up? So, you know, I guess that doesn't really answer your question, but yes, the boys will do what they're going to do in the end. Yeah.
Yeah, I suppose, the fact is that everything's negotiable. And when it comes to getting, more patents done, you generally look for more funding into the pipeline. Now, have you ever been a part of trying to really enforce the patents? I mean, a patent pending is equally enforceable as a patent, correct?
Yeah, so my primary practice is more on the trademark side. So I've done a lot of trademark litigation, trademark enforcement, not as much on the patent side. So on the patent side, I would work with Neil, if we find that there are infringers to stop that infringement. But I don't work that much on the patent enforcement side. It's more on the development and the strategy in combination with Neil, but then also on the trademark enforcement side. Yeah.
I suppose that if you notice somebody that's infringing on your patent, and again, you would basically put them on notice that you think they are,
Right.
and that wouldn't necessarily that might come from Neil, perhaps.
Yeah, it would probably come from me. It would come from
Yeah.
my firm to say, we represent, your intellectual property rights, and we've noticed that you're doing, this particular bad thing. We need you to stop right now, or else we're going to sue you. That's sort of the gist of the first letter that gets sent to any infringer, obviously in less nice terms. And then, how the infringer chooses to respond is sort of anybody's guess, right? So you need to be prepared, at least on the trademark side, if you send a letter like this, to follow it up, right? Patents and trademarks are sort of different in this regard, in that with trademarks, you have to go after every infringer. With patents, you can pick and choose, who you seek to enforce your patent rights against. With trademarks, the whole value of a brand lies in it being unique to you. So you have to go after every infringer of your brand. So you start with a cease and desist letter that says, stop, or we're coming after you. And, I'd say 8 times out of 10, the infringer will stop. The other 2 times you have to, decide what to do going forward. It's a business decision. What is this right worth to you? What damage are they doing to your business, by using your rights without you having allowed them to use it? And how much effort are you willing to put in to stop it? So patent and trademark litigation is not inexpensive. It's probably, one of the more expensive types of litigation that you can engage in. For a trademark infringement proceeding, I usually quote $500,000. So it's not cheap. And you really have to decide, what am I going to get out of this? And that's where the inquiry starts. And if you're going to get something out of it that's worth your while, then that's where our work begins.
Yeah, I suppose the practicality I've gone through down the road of fortunately never really been sued, but the fact is that it causes discussion. So you have to put something over the fence to protect your rights, but then to me, everything's a negotiation after that. Right?
Absolutely, it is. Yeah, absolutely. And you have to make sure that you have a clear idea of what you want to get out. What's your end game before you even go into something like this? Because, litigation of any sort, but particularly in IP, is all consuming. It's consuming of on the financial side, of course, but also, the amount of effort that you need to put in and spend, with your lawyer is significant, right? So it's time that you're spending away from your business. I'm talking myself out of a job here, but it's the truth that there's a reason that people don't like lawyers, right? So even when we're doing our jobs, well, it's not a fun process to engage in always, right? And so you have to decide from the get-go, is this something that I want to pour my energy and effort into for the next 2, 3, 4 years? And sometimes the answer is yes. Sometimes it's worth stopping your competitors from doing what they're doing, and other times it's just not. Yeah.
Well, I would imagine if this happens with my patents, that you'd probably refer me to an IP firm that would like the billable work and not get yourself bogged down with that energy, because it would change the energy of your life, right?
Yeah, I mean, it's the kind of thing where, as long as a client is committed to the process, then I'm happy to do it. It's not that I don't want to engage in the litigation. I very much enjoy that side, but there sort of needs to be clarity up front. That's what I'm trying to express. Yeah.
Yeah, and I guess you can always build your firm up and have more people
Right.
and all those things, give another young engineer a chance to follow your path, right?
That's right. Yeah, exactly.
Maybe it'll be your son one day that'll be
Yeah.
saying, let's sue those people. We gotta sue those people.
Make me
Often the
proud.
kids have an idealistic view. They haven't actually been down a big expensive legal bill before.
Right.
But and you got to admit, some lawyers, unlike you, and unlike Neil, some lawyers would look at that as something to grab and bill against, right?
Yeah, absolutely. But in my experience, if you approach a client that way, it doesn't turn out well, right? I like to be upfront about the commitment that's required, and make sure that there's a valid business reason to go after somebody, to go after an infringer, and sometimes there is. This is not to say that it's never worthwhile, but you have to go in with the understanding. And like you said, everything is a negotiation after you send that preliminary cease and desist letter, right? The vast majority of IP cases settle far before they ever reach a trial. Last I heard, it was something like 5% of IP cases, actually make it to a hearing in the federal court. And so it really is a matter of being clear on what outcome you want from this, right? Is it just that you want the other side to stop doing what they're doing? Is it that you want, damages for or a reimbursement of the profits that they've made from using your IP? And then, sometimes it requires more than just that initial cease and desist letter. It requires starting an action against them. But then again, after that action is started, the vast majority of cases will settle.
Yes, it's logical. In the end, clients in particular, they're business people usually, right?
Right.
So
Yeah.
that's
Exactly.
when you can find an engineer like and a lawyer like yourself and Neil that are business people. Also, right. I believe that there's real value there.
Yeah, I mean, it comes down to a cost benefit analysis, right? In the federal court, even if you're fully successful, the court says, yes, this person was infringing your IP. They're naughty. We're going to slap them on the wrist. Even then, you're usually only going to recover about 30% of the legal fees that you paid. So it's completely unlike provincial courts where costs are awarded to the successful party, usually on a much higher scale. But what you pay your lawyer to pursue an infringer is usually only paid back to you by that infringer if you're completely successful at about 30% of what you paid. It's sometimes a losing proposition.
Yeah, so that's interesting. I want to ask you about legacy, and I'm going to suggest you run for the Conservative Party of Canada. You'd be great. Anyways, but when it comes to legacy, what would you most like to see? Is it to be the best mom ever? Is it to be the best? It's a combination of things, isn't it? For you, you're very balanced.
Yeah, I mean, I think if we look at it sort of as an overall legacy, it's probably to give the best advice ever. I know that you and I often have this conversation where I say to you, Martin, my job is to explain, what I know, to explain what I know of the law, to suggest strategy, to provide you with this information so that we can make a risk assessment together and you have to come to the business decision. So I guess what I would most like my legacy to be is, the provision of good, balanced, informative advice. I'm not going to I'm not going to be the solution. I want to give the information that I can. I want to provide the information that I can to let my clients, my kids, whoever it is, make the best decision that they can make.
Tell me, your mom, what type of engineer is your mom?
My mom is a chemical engineer.
And obviously a great mom, but also, and I think you have a brother, right?
I do. I have a younger brother who is also a lawyer. He does corporate sort of mergers and acquisitions of big companies at a big firm in London, England.
Oh, interesting. So your mom, did she ever express that she was jealous that you were becoming a lawyer?
No, I don't think so. I mean, I think it was always sort of expected growing up that both of us, my brother and I, would go into some sort of science or engineering, which I did. But I think what was sort of the deciding, factor for both my brother and I was that we used to have these conversations around the dinner table where there would be this free exchange of ideas, where we were free to battle it out and express our opinions. And I think that's what sort of built the lawyer in both me and my brother.
Yeah, very good. Tell me, I'm really curious, and don't comment on my patents. Don't be, I'm not fishing for compliments there. I think we have to be creative. We almost have to get rid of our ego, although maybe there's a role of ego to seek the legacy. But you must have a couple stories you can tell our viewers about people who didn't think it was patent worthy and maybe are doing well today with something that worked out for them. A success story or two. You and Neil certainly saw, he was in-house at Nortel, right?
So Neil has moved around. Yeah. He's had his firm for the last 30 or 35 years, I guess. But before sort of breaking out, he was the VP of IP at JDS Uniphase. But I mean, it's sort of an interesting, word that you've chosen, legacy. So, IP is sort of legacy planning in both senses of the term, right? So it's recording your contribution to society, and there's a saleable asset left over, behind you to pass on, once you pass on. So it's sort of an interesting term that you use. I'm trying to think of a story that I can tell you about, when we thought that something wasn't patentable, but it ended up being so. I mean, I think there's always a give and take and an interchange that happens where we sort of do a dance with our clients where we have to get to the heart of, what's new, what's inventive about this technology that somebody's come up with. Because oftentimes there's, there are elements of any invention that aren't necessarily new, and then there are the elements that are. So it's sort of, our job, and really Neil's job, to sort of nitpick and figure out, what is it that is new and interesting about this concept.
Define that process of developing a legacy, but let's say in Neil's case, he does a lot of work at trying to save you money in the sense that he'll try to find the prior art. It's not like he just flips it in. The quality of a patent agent, from what I understand, and particularly Neil, I mean, there's been one or two where he just wouldn't do it. He just wouldn't submit it, right? Even though I saw a business purpose for it.
Yeah, I mean, I think that's part of what makes Neil so brilliant, is that he has the ability to pick and choose, what is important from what you're telling him, right? So, I think even in situations where we've found prior art and deemed it not patentable for one reason or another, there are still strategic moves that we can make to protect your IP, right? We can still file, a provisional application as an example, and sort of continuously file the provisional over and over so that you have something to hold up in front of people, including the bank, for example, to get access to financing. So you can use the value of that IP as collateral for financing, or for outside investors, right? Investors see that you're putting in the effort to protect your assets, and they're more likely to have confidence in you as a result of that. So there are sort of various strategies that we can come up with. But yes, I would agree that that's part of what makes Neil so brilliant, is that he's able to sort of see what's out there and dance around it.
So I think it's also important that the listeners understand that if they innovate something on a project, that they often should act on it right away. I remember I did something in Nova Scotia that arguably could be patentable, but I wasn't really on to Neil or the potential of that 3 years ago when I did that. And you get all the other benefits of charging your hourly rate or helping somebody, which, ultimately helping somebody is what it's about. I find the reward is really about helping people now, and not so much about myself. But Neil, let's comment a little bit about the fact that when you're working in a company and there's things happening, that company thinks they own everything because they paid you a salary, right? Now, how fair is that? I mean, that's what happens, because as we consolidate industry, these companies are buying these patents. Like Nortel, did they buy JD? I remember this Uniphase company. They morphed it.
No, they were separate companies, but I don't know how fair or not fair it is that these companies own the IP that's created by their employees. It always depends on what exactly is set out in your employment agreement with any company that you're employed by. There are certain assumptions that are made by people that may be incorrect. So we have to read your employment agreement in the context of what it is you're trying to do and figure out where the IP is going. These companies would likely argue that it's fair on the basis that they're paying you to do things like that, right? That's what they're buying from you in terms of services. But you raised another good point that about the Nova Scotia project, where you do have a limited opportunity to seek patent protection. In Canada and the US, there's a 1 year period after you publicly disclose something that you have to file a patent application. But regardless of when you file during that 1 year, you want to make sure that you're covered in terms of your disclosure of your ideas to third parties, right? So you don't want to go around giving out your ideas without being covered by a non-disclosure agreement that isn't always the best legal protection, but sort of sets out the boundaries between you and the person that you're disclosing this idea to, of what the expectations are. So those are sort of three different concepts that I mashed all together there, but really important that when you disclose your ideas that, it's subject to a non-disclosure agreement. Make sure that you file your patent applications as soon as possible after you invent something, but in any event, no later than a year later. And in certain countries, there's no such grace period allowed. So you have to make sure that if you want to file into foreign countries, that you're within their grace periods as well. Yeah, no, I think those are really important concepts.
Just when you talk about an employment contract, I really just would shake people's hands when I used to hire them and was very informal with things like that. And you might confirm it with a letter. And most people, whether they're a young engineer or, I hired a lot of engineers and a lot of supervisors, but all those tradesmen and all those supervisors, they would always come up with good ideas. And the burden, I think, is on the employee. But even now, I recognize that we can add advice to our listeners right now, in the sense that if I was to give any advice to somebody who's innovative, ask for 50% of anything that comes out of a jointly held patent like that. If the company, maybe that's the win-win, right?
Yeah.
Where something could be won by the employee that you're recruiting, if they have a PhD and they're pretty bright, and they're going to go down the road of inventing something with you. Even an employer, perhaps today's employers should have an employment contract that doesn't just take everything.
Yep, like
that
everything
mentions
else.
that. Yeah.
Like everything else, it's a matter of negotiation, right? We can put any of these ideas into writing, but it's a matter of having clear expectations up front. And I mean, you're right that in the current marketplace that we're in, where employees have more power than they used to, right? There's sort of been a great walkout, right? Employees are demanding better rights, better pay, better benefits. This is a benefit that employers can offer to their employees, which is, the ability to participate in the revenue from patented inventions that those employees come up with. Yeah, it's a great idea.
Obviously the employee, if he gets an idea and he's aware that the company's going to grab that idea, as long as he's employed there, then the employee jumps out of the company, starts a new company because he wants to own the idea, right? So it might reduce negative turnover. My mind goes to the innovation all the time. And when I had the previous firm and I went through that shotgun thing, innovation in foundations was my motto. It sounded good, and we lived it. But the truth is, there's innovation in every industry.
Right.
So the word innovation is really an intriguing word, and certainly I appreciate that you're a very innovative patent agent. So innovation in trademarks and intellectual property might be a good name for your firm. Do you have to name your law firm after you, like people say Burk Law, right?
Yeah, not anymore. There used to be a requirement in Ontario that the name of the firm reflected the partners. But no, now you have firms that name themselves, whatever they'd like. But I think Burke is a good, strong name. So
well, it could be part of it.
That happened.
Maybe you should say, Burke Intellectual Property Innovation. But certainly you're very innovative, and I really appreciate the close to an hour we've spent. And do you have any other questions for myself? Generally it's two-way with us, Ashley. I really don't know about doing more patents. It's a lot of work to get them going.
Yeah, no, I think that your ideas are fantastic in every way. It's when I refer to you without naming you, I always say that my most prolific client, and that's referring to you because you've got these genuinely great but also numerous ideas about how we can sort of take care of the environment, and I appreciate it. So
yeah, we share that, and a lot of readers do. Today the green tech, the green innovation, it's a must, and we would hope to have a long-term relationship with you, Ashley, and whatever we can do to help you in your business, we'll do it. And thanks very much for being on the show. I just want to say at the end of my podcast now, I want to point out that we have a 188 CO2 Feng line, and on our website, we're going to put our value engineering podcasts. And on YouTube, we have this channel. If you can subscribe to these as they come out, they're generally always one or two, and they're not live streamed, but they're one or two in the pipeline all the time. And we're committed to doing one a week. And what I want to try and do is get particularly geotechnical and energy focus here with, an invite to anyone listening, anyone down the road who listens, to write us and be a guest on our show. I don't need to know everybody that's a guest. It's comfort level to know you. And, but, the concept has to grow bigger. you know, I'd like to get the associate partner concept to be 1,000 years of experience on the bench. People like yourself that aren't out for always billable hours. They're really out for the advancement of earth honoring systems. So if you share the values, give us a call. Anyway, thanks again.